Good morning, all of you. Today I'll be presenting on the topic Chorzow Factory, which was decided by Permanent Court of International Justice in 1927. So, this case was about a place called Sicilia where uprising was happening, and later on it got divided into Upper Sicilia and Lower Sicilia. So, in Upper Sicilia, plebiscite happened and majority of the people, that is 31,864 voters, have voted to remain in Germany, and 10,764 voters opted for Poland. Later on, in Upper Sicilia, this Chorzow place was situated where two factories were there named as Opsicia and Stikostok. I'm sorry for my pronouncement as I'm not aware of German. Then it was finally settled by Permanent Court of International Justice, which is now known as International Court of Justice ICJ, and they have held a precedent which is just in international relations. And court has also held few significant points which are very important for international relations. First one is state to be held responsible for expropriation of alien property. Basically, whatever alien property has been destroyed or used or exploited must be made good either through payments or any other means. The second point which was laid in this case was that nations are responsible for the act of the government organs or officers. Basically, they are talking about vicarious liability, that master will be responsible for the acts of servant. Then the third point which was laid in this case was reparation. Reparation is basically indemnifying the loss either through payments or by other means if a loss has been caused by one state to other state. This is the basic principle or general principle of international law. Coming to the more detailed version of this case, so we will talk about the background of the case. The case is about the violation of international agreement wherein whether Poland can be made liable for violation of Section 6 of Geneva Convention. The aftermath of the First World War led to a bipartite agreement between Germany and Poland regarding the transfer of Upper Sicilia area to Poland, in which the state would not forfeit any property of Germany. Next, we will talk about the claim for indemnity. So, indemnity, which is a contractual obligations of one party, that is indemnifier, to compensate the loss incurred to the party indemnity holder due to the acts of the indemnitor or any other party. Coming to the facts of the case, it should be noted that legal aspects of the case underlies a political interest for both nations. Accordingly, a series of judgments issued by the Permanent Court of International Justice led to the court acquiring jurisdiction in resolving the dispute of the parties. The two factories called Becher and Obsessors are both German rich in series of instruments relating to intertransfer of companies' shares. Therefore, it is vested with the national interest of Germany. Coming to the substantial submissions raised to the court by Germany. First was by reason of Poland's attitude in respect of these two factories declared by the court to be not in conformity with the provision of Article 6 of Geneva Convention and consequently a claim for damages. Compensation be paid by Polish government for the damage caused to the companies. Then regarding the mode of payment, payment within 1 month of judgment for the possession of working capital thereof. All claims subject to 6% interest. No nitrate lime and no nitrate ammonia should be exported to Germany, US, France, or Italy. That the application be dismissed. In alternative, the claim for indemnity should be provisionally suspended. In the event of award, previous withdrawal by the said company before the German-Polish mixed tribunal and formal abandonment by it of any claim against the acts of Poland when the civil tribunal of the Polish government had already rendered favorable decisions in favor of this company. In any case, that the German government hand over the shares of Berish and the other company named as Oberschlich. Now, the questions which were raised before the Permanent Court of International Justice. So the first question which was raised was whether or not Germany is entitled to compensation of both companies in their private capacity as well as to the violation of Poland with respect to the violation of international agreement. Second, whether or not the value submitted hitherto the court by German application is meritorious. Third question which was raised was whether the application of stopping production of the enumerated products are valid. Fourth question which was raised before the Permanent Court of International Justice is whether or not Municipal Tribunal of Poland supersedes the jurisdiction of the court in terms of pending cases therein. The fifth question which was raised was whether or not the Polish government is entitled to set off in the claim. Now, what was the resolution being made? So, firstly, in justifying the PCIJ's jurisdiction, the interpretation of Article 36 of the Statute of the Court was cited as the basis to justify its jurisdiction. The article said the parties can go to the court in all or any of the classes of legal dispute concerning A. The interpretation of treaty. B. The existence of any fact which, if established, would constitute a breach of an international obligation. C. The nature or extent of the reparation to be made for the breach of an international obligation. It should be implied in the negotiations of the parties that factory could no longer be restored in kind. The court resolved to establish the question of German government's own right. It brought the suit not as a representative of the individual who suffered injury but at its own behalf. So basically they are telling that this case has been brought not as a representative of individual, those who have suffered loss, but by the state only. So the German government is the party here. Then the court moved to consider the value of company's worth to establish the compensation that is due for the violation of convention. So court also has established the value of the company, how much worth it will be. In terms of the value of the company, hypothetically, in consideration of the circumstances in which it would continue to operate. In relation to the damages suffered, three fundamental questions arises. What are the fundamental questions? We will go next. First, the existence of the obligation to make reparation. So, how much obliged the party is to make a reparation? Then, the existence of the damage which must serve as a basis for the calculation of indemnity. So, how much damage has been caused to the factories by Poland must be assessed. Then, the extent of damage whereof the court resolved of 9-3. So 9/3. So the court resolved that and granted the judgment to the effect that the Polish government, in respect to two companies in attitude declared by the court to not to be in accordance with Article 6 of Geneva Conventions. Then it also ruled that dismisses the plea of the respondent government with respect to the exclusion and injunction of compensation due and the submission made by the same in the effect of German government, handing out the shares to the Polish government in relations to the municipal proceedings. So, what the court has said that the shares should be transferred to the Polish government in relation to the municipal proceedings. Furthermore, court also dismissed the submission of German government in relation to the terms of stopping the exports of nitrate lime and nitrate ammonia. Thank you.